The Supreme Court just handed down a 5-4 decision that every gun owner and driver across this country absolutely must understand right now. The officer approaches your window and delivers the words that shift everything in an instant. Exit the vehicle. Every single day, motorists make one critical error in that exact moment. They swing the door open without uttering a single syllable. That wordless exit hands law enforcement legal advantages that most people never even realize they just surrendered. After reviewing hundreds of traffic stop cases and diving deep into the case law that controls these interactions, I have identified the most legally vulnerable window of any traffic stop. It is not the moment the lights flash behind you. It is the 15 seconds before your feet make contact with the ground. I am going to walk you through 5 precise actions that shield you during that window, along with the exact words to speak before you ever reach for that door handle. Stay with me, because mistake number 3 is the one that leaves people genuinely stunned the first time they hear it. This content is educational in nature only. For guidance specific to your situation, please consult a licensed attorney in your area. Mistake number 1 is not knowing whether the officer is making a request or issuing a command. Consider this scenario. The officer leans toward your window and says, "Hey, mind stepping out for a moment?" And you immediately comply. What most people fail to understand is that they just surrendered something important. The word mind is not a directive. It is an invitation. And under the law, those two things carry entirely different weight. Under Pennsylvania versus Mims, decided in 1977, officers have the authority to direct a driver out of a lawfully stopped vehicle on officer safety grounds. But that authority only exists when an actual command is given. A casual request carries no such legal force. When you comply with a request, your exit appears entirely voluntary on body camera footage. Courts have consistently described voluntary exits as implied willingness to participate in the broader interaction that follows. The question you need to ask before your hand ever touches that door handle is this: "Officer, are you asking me or commanding me to step out of this vehicle?" Deliver it calmly, deliver it respectfully. That single question requires the officer to place their actual authority on the record, captured by both their camera and yours. If they are asking, you retain the right to decline. If they are commanding, you now have full clarity about your legal position and can proceed accordingly. Here is how this plays out in practice. The wrong approach. Officer says, "Mind stepping out for a second?" Driver opens the door in silence. That registers as an apparently consensual exit on camera. The officer has issued no command and established no legal basis on the record, but the footage shows what appears to be a driver who cooperated fully, which sets the stage for arguments about implied consent to everything that comes afterward. The right approach. Officer says, "Mind stepping out for a second?" Driver responds calmly, "Officer, are you asking me or commanding me to step out of this vehicle?" If the officer says it is a request, the driver may respectfully decline. If the officer confirms it is a command, the driver follows up with, "And for the record, what is the legal basis for that command?" The officer either states officer safety, which is their recognized authority under MIMS, or makes it clear they have no defined legal footing at all. Either outcome is now preserved on camera. The driver now has legal clarity locked into the documented record. Repeat this phrase 3 times and commit it to memory. "Officer, are you asking me or commanding me to step out?" To "Officer, are you asking me or commanding me to step out?" "Officer, are you asking me or commanding me to step out?" The bottom line on mistake number 1: never open that door before establishing whether you are facing a request or a command. That one question fundamentally shifts the entire legal dynamic of the stop. Now here's the part that most people completely overlook. Understanding the difference between a request and a command protects you in that specific moment. But the Supreme Court has established that your Fifth Amendment protections do not engage on their own automatically. There is a significant gap between asserting your Fourth Amendment rights and shielding yourself from self-incrimination. Two landmark rulings expose this gap directly: Salinas versus Texas from 2013 and Berghus versus Tompkins from 2010. Mistake number 2 sends drivers falling straight into it. Mistake number 2 is going silent without formally invoking your right to remain silent. This is the legal principle that genuinely infuriates people, and understandably so. In Salinas versus Texas, the Supreme Court ruled that when someone goes quiet during non-custodial questioning, meaning questioning at a traffic stop before any arrest, without explicitly asserting the Fifth Amendment, prosecutors are permitted to present that silence in court as an indication of guilt. In Berghuis versus Tompkins, a suspect sat through nearly 3 hours of interrogation, largely without speaking, then made one brief comment. The court ruled he had waived his rights because he never clearly and explicitly asserted them. The combined legal principle is this: you must speak in order to protect your right to stay silent. Silence without explicit invocation is not a defense. It is a tool that prosecutors can and will use against you. Before that door swings open, here is what needs to be captured on body camera footage. State clearly and calmly, officer, I am asserting my Fifth Amendment right to remain silent. I do not consent to any searches of my person, my vehicle, or my belongings, and I am requesting to speak with an attorney before responding to any questions. 3 sentences, 15 seconds. Legal protections documented before your foot ever contacts the pavement. Here is why every single sentence carries weight. Explicitly invoking the Fifth satisfies the requirements established in Salinas and Berghuis. Declaring that you do not consent to searches guards you under the Fourth Amendment because courts assess consent through the totality of circumstances, and passive compliance has repeatedly been interpreted as implied agreement. Requesting an attorney signals your Sixth Amendment awareness and creates a documented record that works in your favor if the stop takes a turn for the worse, the wrong way. Officer orders driver out. Driver exits in silence. Officer asks, "Where are you headed this evening?" Driver responds. One answer leads to the next. Driver mentions having drinks at dinner, the right way. Before the door opens, the driver states, "I am asserting my Fifth Amendment right to remain silent. I do not consent to any searches. I am requesting an attorney." Driver exits. Driver remains quiet. Say this phrase 3 times. I assert my Fifth Amendment right to remain silent. I assert my Fifth Amendment right to remain silent. I assert my Fifth Amendment right to remain silent. The bottom line on mistake number 2. Silence by itself provides no constitutional protection. The Supreme Court demands an explicit verbal invocation to secure that shield. Speak those words before you open the door. You have now secured your right to silence and your protection against unreasonable searches. But here is the gap most drivers never recognize. The physical act of stepping out of your vehicle can appear to be voluntary cooperation unless you put one additional thing on the record before your hand even touches the door handle. And this is the point that surprises absolutely everyone when they encounter it for the first time. Mistake number 3 is exiting the vehicle without announcing the nature of your compliance. 3 seconds. Before you open that door, before your fingers even graze the handle, one more sentence must be placed on the record. Here it is. I am exiting under compulsion and under protest, and my hands will remain fully visible at all times. This single phrase accomplishes 3 critical things simultaneously. First, it establishes that your exit was compelled rather than voluntary. Voluntariness sits at the center of how courts evaluate everything that follows your exit. A compelled exit, documented in your own words, eliminates the argument that you were freely cooperating beyond what the law required of you. Second, the phrase "under protest" is a recognized legal signal that any reviewing court will identify immediately. It communicates clearly that you were not a willing participant beyond the legal minimum demanded of you. Third, announcing that your hands will remain visible removes any potential officer claim of furtive or suspicious movements that might otherwise justify a pat-down search. Here is how body camera footage functions differently with and without your verbal declaration. Without your words, the footage simply shows a door opening, feet landing on the pavement, and a body emerging. It appears cooperative. With your declaration, the footage documents that this individual exited under legal compulsion, under explicit protest, with hands fully visible throughout. That is the kind of evidence your attorney can use at a suppression hearing to challenge anything that occurred after you stepped out. Here is the detail that almost every legal content creator misses entirely. Close your door when you exit. Stepping out and leaving the door wide open dramatically expands what falls under the plain view doctrine, as established in Horton versus California in 1990. Officers can observe your vehicle interior from entirely new vantage points. A flashlight sweep across your interior does not constitute a search under current law. It is plain view observation. Anything visible from a position officers are lawfully permitted to occupy can be seized without a warrant. Closing the door behind you limits that exposure and requires any further observation to rest on a legal basis beyond plain view. Repeat this 3 times. I am exiting under compulsion and under protest, and my hands will remain visible. I am exiting under compulsion and under protest, and my hands will remain visible. I am exiting under compulsion and under protest, and my hands will remain visible. The bottom line on mistake number 3. Your exit must be documented as compelled, not voluntary. Announce your compliance. Declare your protest. Close the door behind you. You have now protected the exit and minimized visual access to your vehicle's interior. But once you are standing outside, an entirely different body of legal rules applies to your physical person. The Supreme Court addressed this directly in Arizona versus Johnson from 2009. And what the court established there connects directly to mistake number 4. Mistake number 4 is responding to questions while standing outside the vehicle. The moment you step out, the environment shifts entirely. Officers are trained to use that environment to their advantage. You are exposed. Patrol lights illuminate you from behind. Body cameras capture you from multiple angles simultaneously. And officers will engage you with friendly, low-pressure conversational questions. How are you doing tonight? Big drive? Where are you coming from? Drivers answer because standing on the side of the road under those lights, staying silent, feels like an admission of guilt. Here is what the law actually establishes. Under Rodriguez versus United States from 2015, once an officer has completed the tasks directly tied to the traffic stop, verifying your license, registration, and insurance, then issuing or deciding on a citation, the legal justification for continuing to detain you has expired. Any questioning beyond that point requires independent, articulable, reasonable suspicion. Every response you provide gives officers potential material to construct that suspicion. Here is how the escalation unfolds when you answer. Officer asks where you are coming from. Driver mentions dinner with friends. Officer asks whether you consumed anything alcoholic. Driver says just a single drink. The stop has now transformed into a DUI investigation. Officer asks whether anything illegal is present in the vehicle. Driver says no. Officer says, "Well, then I assume you have no objection to letting me take a look." The driver has now walked directly into a consent trap. Every word of every answer that built that case was captured on camera. The right approach. You already asserted your Fifth Amendment right before stepping out. Every question the officer poses from that point forward receives the same calm, firm, polite response. I have asserted my right to remain silent, No attitude, no sarcasm. Do not mirror aggressive energy. Do not raise your voice. Stay calm, stay courteous, but remain firm. Cooperation does not require conversation. You can treat an officer with complete respect while simultaneously exercising every constitutional protection the law extends to you. When you believe the stop has run its legal course, ask this specific question. Has the purpose of this stop been concluded? Am I free to leave? Under Rodriguez, posing that question on camera requires the officer to either release you or state a new independent legal basis for continuing to hold you. If no such basis exists, that fact is now part of the documented record. Say these words 3 times. Am I free to leave? Am I free to leave? Am I free to leave? The bottom line on mistake number 4. Every answer you give while standing outside that vehicle is potential evidence being built against you. Your pre-exit invocation provides protection, but only if you actually stop speaking. Stay quiet. Stay protected. One more critical point before we move forward. Officers are legally permitted to deceive you during a traffic stop. They can claim to possess evidence they do not actually have. They can say a witness placed you at a scene when no such witness exists. They can assure you that cooperating will improve your situation when legally it alters their authority not at all. This is precisely why your invocation carries such weight. Not because you have anything to conceal, but because you genuinely have no way of knowing what they believe, what they claim, or how they will characterize anything you say. The only reliable response after invoking your rights is to say nothing beyond, I have asserted my right to remain silent and I want to speak with an attorney. Mistake number 5 is failing to execute the complete opening 30 seconds of the stop correctly before you ever exit the vehicle. The first 30 seconds of any traffic stop form the legal foundation that every right you exercise afterward rests upon. Here is the exact sequence. Pull over safely using your turn signal. Activate your interior dome light if it is dark outside. Switch off your engine. Place both hands on the steering wheel in plain view. Lower your window 2 to 4 inches only. Do not open the door until you have determined whether you are facing a request or a command. When asked to produce documents, verbally announce every movement before you make it. I am reaching toward my glove compartment to retrieve my registration. My hands will remain visible throughout. Then state your 3 sentences before opening the door. First sentence, I am asserting my 5th Amendment right to remain silent, and I do not consent to any searches of my person, my vehicle, or my belongings. Second sentence, Officer, are you commanding me to exit? And if so, what is the legal basis for that command? Third sentence, I am exiting under compulsion and under protest, and my hands will remain fully visible. Then step out, close the door, remain silent, and ask when appropriate, am I free to leave? Commit your 4 core phrases to memory. First, am I free to leave? Ask it early. The answer defines what legal situation you are actually in. Second, I assert my 5th Amendment right to remain silent. Say it explicitly before you open the door. Silence alone is legally insufficient under Salinas and Berghuis. The words themselves must be spoken aloud. Third, I do not consent to searches. State it clearly, covering your person, your vehicle, and your belongings. Fourth, I want to speak with an attorney. Say it before any questioning begins and before any arrest takes place. Now, 2 state-specific points worth noting, because the law varies by jurisdiction and general knowledge only carries you so far. In stop and identify states, which include Texas, Nevada, and Colorado, you are legally obligated to provide your name when lawfully detained. Refusing to do so can result in a separate obstruction charge. This is important enough to say again. In these states, Providing your name is a legal requirement. It is not a violation of your rights, it is the law of that state. In states that do not carry stop and identify statutes, such as California and Oregon, you have broader protections and may decline to identify yourself without creating a separate legal issue. Regarding marijuana as probable cause, in Colorado and Maryland, courts have placed substantial limitations on the use of marijuana odor alone as grounds for a vehicle search. In Texas and throughout much of the southeastern United States, the smell of marijuana continues to provide probable cause for a full vehicle search under current case law. Regarding window-lowering requirements, most states carry no specific statute dictating how far you must lower your window during a traffic stop. The 2 to 4 inch standard is a practical approach that allows for document exchange while limiting plain view exposure to your vehicle's interior. Familiarize yourself with the specific laws in your home state. This is educational analysis, not legal advice tailored to your individual circumstances. This content is for educational purposes only and does not constitute legal advice. Always consult with a qualified, licensed attorney in your state regarding your specific situation. Here is the central principle underlying everything covered in this video. The 15 seconds before your feet touch the pavement are the most legally consequential seconds of your entire traffic stop. Use them with intention. Speak your rights into the record before that door ever opens. Your 4 phrases one final time. Am I free to leave? I assert my Fifth Amendment right to remain silent. I do not consent to searches. I want to speak with an attorney. Now here is where your legal education continues. Multiple constitutional protections operate together during traffic stops, and each carries its own rules governing when and how they apply. I break down exactly how those protections interact across different traffic stop scenarios in the next video, which is visible on your screen right now. Click it to continue building your legal knowledge base. Drop a comment below letting us know where you are watching from and what time it is there right now. It genuinely helps this channel more than most people realize. Remember this, understanding the law is not the same as confronting it. It is participating in it fully and intelligently. Stay safe out there, stay respectful, and stay protected.